Okay, so let's continue. David John Walter, Petition of Right. Okay, this is going to be from page 51 up to page 60. Now, so we go to the 1988 Partnership Act 1988. Be it enacted by the Queen's Most Excellent Majesty by and with the advice and consent of the Legislative Assembly of Queensland in Parliament assembled and authority of the same as follows. Okay, so that wasn't done by Queen Elizabeth II. Again, you can see this is the Queensland Elizabeth II Regiment 1988. Now, to allow any private persons being members of the registered parties, political parties, elected and sworn and inside the Legislative Assembly, because we should have the Legislative Assembly, the Legislative Council inside the Constitution in 1867, that's the original Constitution for Queensland, enter into limited partnership agreements with any private persons, and it's in Australian decimal currency, which pretty much hold no authority. Now, this is the Queensland seal. This is the legitimate Queensland seal. Okay, so I just want you to remember. Okay, now, then we're gonna go back to the 1967. This is the salaries of the judges. Again, just remember there is no royal assent of 1960s. You can ask your Attorney General of the state or the Attorney General of Australia to provide you the royal assent letters patent, but it does not exist. Okay, so that was back in 1960s. So pretty much as of 1966, everything is smoke and mirrors and hocus pocus pocus. Now, in 1967, with the private introduction of the Australian currency, 14th of February 1966, just remember we didn't have a referendum when we're supposed to be. Your Majesty the Queen refused to pass any act of Legislative Assembly to allow any poison judges of the Supreme Court or District Courts of Queensland to receive any private salaries and allowances of foreign queen and the foreign nation of power and hold to the seals the foreign queen to impose any pecuniary penalties or any fines in any foreign currency or imprison person on the land of the Crown. Okay, so 1966, 14th of February 1966, as I mentioned, this is very important date when they introduced the unlawful Australian government, called de facto Australian government. They introduced the private Australian decimal currency, legal tender without people's referendum. So everything was basically happening without people's referendum, introducing the metric measurements without people referendum, and pretty much everything is smoke and mirrors and hocus pocus pocus as of 14th of February 1966, because commencing on the morning, Monday, now just remember David John Walter used to work in a bank in that day, and he clearly remembers no political appointed, when they changed the legal tender, no political appointed justice in any Supreme Court of Queensland who has accepted payment in Australian decimal currency for the private services to the state. Private services cannot impose any pecuniary penalty in Australian decimal currency and cannot imprison any private person for any terms of residence or hold to the Criminal Code Act 1899. Section 63 as the term self-hold authority on individual person only. So this is actually, if you're in Queensland, that's the Criminal Code Act 1899 63 with number 9. Okay, so that's only who are a member of the private political party, who work for the private political party, who are governmental employees, because they are private laws, private statutory laws, and it's only applied to statutes and their own employees. And if you don't know the difference between the legal fiction name and the living being, because they cannot charge the living being, they do not hold authority, because we got God-given rights. Okay, so highest authority is God and not Dan. Now, every political Australian judge justice each holds signed person-to-person contract in de facto relationship with the Chief Executive Officer of the Australian Government, Prime Minister of Australia, and paid out of the profits of the firm in private currency of the firm in Australia in electronic currency as hold to the Electronic Transaction Act 1999. So they're getting paid in Australian decimal currency, which is a private money for the private political party. No political sworn and appointed judge justice in any private positions in any private Australian court cannot imprison any person on the land of the Crown for any perpetrated civil law criminal offence of the privately elected members of the registered political parties of the Australian government, the holders of the seal affixed to the Crimes Act 1914. Okay, so this is what it is. This is a prima facie evidence. It's forensic document. You guys, you got everything in this document. If you can comprehend this document, you are gold. You are full of gold of knowledge and information. So again, gonna go back to the Statutory Revision Act 1973, holds no seal any perpetuated Queen of Australia, head of the Commonwealth, and holding the royal style entirely in any manner or forms as hold to the seal affixed on the Judiciary 1903 number 6. Okay, and even Judiciary Act 1903, if you listen up Rod Calaton, he's been talking about the Judiciary Act. Okay, now the Statutory Law Revision Act, I'd strongly recommend you to read it through, have a dip into that a little bit, because that's when they created there is no seal. So statutory law applies only for statutes, etc., etc. Political appointed judges are remunerated for the private services to the members of the registered political parties in an Australian government from the profits of the business through the Currency Act 1965. Hold the public seal affixed to the Remuneration Tribunal Act 1973 and hold the Chief Executive Officer of the Australian Government, the Prime Minister of Australia. Now, Section 78. And this is the Judiciary Act 1903, okay, to make a provision exercise judicial power of the Commonwealth. 78. In every court exercising federal jurisdiction, the parties may appear personally or by such a barrister solicitors as by laws and rules regulating the practice of those courts respectively are permitted to appear there. Okay, so this is appearance of the parties, and this goes back to the Judiciary Act 1903. And this goes back to the 78. So it's a good one to look into that. Then you got the Constitution Act 1867. Okay, so this is the original constitution. And then here we go. And then whensoever the demise of her present majesty or of any her successors to the crown of the said United Kingdom shall be notified by the governor of the colony to say the council and assembly respecting the members of the said council and assembly shall before they shall permitted to sit and vote there and take and subscribe the like of allegiance to the successor for the time being to the said crown. Okay, so pretty much this is up to page 60, and talking about 14th of February 1966, what's happened, how we got our lawful magistrates, our lawful judges, and etc., and how basically pretty much they are a private corporation who are running the show. Now this was up to page 60, and I will be back soon from 61 up till 70.